My name is Jonathan Ackerman, and I want to briefly introduce myself. I'm a tax attorney with a Master of Laws in Taxation from Georgetown University Law Center. I've been practicing for just over 25 years, and I've been working with a number of different exempt organizations, both public and private charities and other exempt organizations. And what I do is I help them in their creation and in their governance, in tax qualification issues and tax compliance issues. There are three general duties that a fiduciary owes. One is a duty of care, another is a duty of loyalty, and the third is the duty of obedience. So I'm going to start with the duty of care, and I'm going to talk first about the corporate duty of care. And basically the rule is that a director has to perform their duties in good faith, in a manner the director believes to be in the best interest of the corporation, and with such care, including reasonable inquiry, as is appropriate under the circumstances. Now, this relates to both decision-making, such as exercising a reasonable level of care, and oversight, and participating in the governance issues of the charity. So, a fiduciary basically has to be in a position to render an independent judgment on the decisions they make on behalf of the charity. So the second fiduciary duty that I wanted to discuss was the duty of loyalty. Now, fiduciaries must act to advance and achieve the purposes and mission of the nonprofit, rather than to benefit the interests of any private person. Now, common examples would be a conflict of interest, which is transactions between a disqualified person or an insider to the nonprofit and the transaction with the nonprofit, or the corporate opportunity doctrine, which is basically where the nonprofit may have an idea to produce revenues, and an insider ends up taking that idea, utilizing it outside of the nonprofit for their own private benefit. Now, I also wanted to discuss a charity that is structured as a trust, because the fiduciaries actually have a higher standard of care. So, for instance, a fiduciary of a charitable trust can be liable for simple negligence as opposed to gross negligence, and especially as it relates to self-dealing. Even if the transaction is made in good faith and the deal was fair and reasonable to the charity, a fiduciary can get no profit from a transaction. Now, federal tax law isn't that strict and doesn't distinguish between a charitable trust or a charitable corporation for purposes of excise taxes for public charities, as well as the self-dealing taxes for private foundation. The duty of obedience is the third general duty that fiduciaries have. Now, the duty of obedience relates to carrying out the charitable mission and, of course, complying with all laws. So, failing to modify the activities based on changes in the law, or failing to oversee agents and employees, or changing the charity's activities so that it's outside the scope of the governing instruments, would all violate this duty of obedience. There are several methods for limiting the liability of your fiduciaries. And the first is indemnification under state law. So you may have statutory provisions, or in your governing instrument, you may provide protections, as well as by contract. But of course, those types of indemnifications are only as viable as the financial strength of the charity. So you may want to go out and get insurance, such as liability insurance, or specifically directors and officers insurance. The third way is there's actually a statutory immunity, both under federal law and state law, for purposes of protecting your volunteers, which includes the board members and directors, the board members and the officers. But there are some exceptions to those rules that you would think, like willful misconduct, you're not going to be protected, and others. And then there are certain conditions, such as having certain levels of the insurance, the liability insurance I referenced earlier.